All right. The Court of Appeal went for the 6th District of the State of Florida town session. Jonathan Mary Alice Martella, judge presiding. All persons having business before the court solemnly give attention and will be heard. God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. We have on our docket today one case. It's 16-205 Captiva Drive LLC versus Richard Levinson et al. Both sides will be given 20 minutes to make arguments. The appellant, when you're ready, you can reserve for rebuttal as much time as you would like. We typically reserve 5 minutes unless you tell us otherwise. Our proceeding this morning is going to be recorded and will be recast on YouTube. Whenever you're ready, counsel.
May it please the court. My name is Chris Donovan. I'm here on behalf of the appellant, 16-205 Captiva Drive LLC. A couple of preliminary matters. I would like to reserve 5 minutes for rebuttal. Also, the appellant is an LLC, so I would probably just refer to it as an LLC, and the appellee is technically a trust. The trustee is appearing on it, but I'll probably just refer to it as the trust as well. In my briefs, I raised 3 arguments. Today, though, I will focus on the first 2 unless there's specific questions related to the third argument, but I'll stand on my brief otherwise. The first issue is the trial court erred in granting summary judgment because the trust failed to meet its summary judgment burden. The trust had the summary judgment burden in order to prove that it complied with the conditions precedent to payment, namely that the $230 pressure washing invoice was actually received by the LLC or its owner, which is Colm Lanigan. The trust actually presented insufficient or certainly not competent evidence in support of summary judgment. In fact, it admitted that it had no evidence of receipt by the LLC or anyone associated with the LLC. Instead, it essentially relied on 3 pieces of evidence, none of which support summary judgment.
Mr. Sullivan, let me ask you, we understand your arguments about the timeliness of the motion and the hearing and the other matters that were raised and rehearing, et cetera. But focusing only on the movant's summary judgment motion and summary judgment evidence cited therein, how do you win based solely on that? What do you have to show to establish that the initial burden wasn't met?
Your Honor, what we have to prove is that the evidence that the trust presented was insufficient for summary judgment, because at the end of the day, the trust had the initial burden, which the trust seemed to insinuate in the answer brief that it could satisfy that burden, or that it had really no major duty of satisfying that burden other than proving that the LLC lacked evidence of receipt. And that's not the accurate standard for in a situation where it's the plaintiff moving and the plaintiff has the ultimate burden in trial. Therefore, the plaintiff has the burden to come forward with affirmative evidence that is sufficient to prove an entitlement to summary judgment.
But they did send it to an address it was received by a person. My understanding, you can correct me if you disagree with this, but my understanding is there's no objection as to the trial court's consideration of the printout at that initial hearing. I know it might come in later at the rehearing. So if the trial judge is looking at an Abu Dhabi address and is looking at a signature, they're saying, Judge, this has worked in the past. Is that not enough? And why not? For the burden to then shift to the respondent to say, actually, Judge, here's why not. And does that happen?
I think there's a lot there that I have to unpack.
Yeah, compound, right?
The regardless of whether or not there was evidentiary objections, the document, this receipt, this computer printout that purports to be a Federal Express a receipt of delivery does not support receipt under the summary judgment standard, because there's nothing connecting this document with the actual demand. In other words, when you compare the two, the demand doesn't say that it was sent by Federal Express. It doesn't say that it was has a tracking number, but this receipt.
Did y'all tell that to the trial judge?
I believe that it was at least told on rehearing. Yes, Your Honor. What was also told at the trial judge at the hearing was that nobody knew who this ex Zeus was, or certainly whether or not he had apparent authority to sign on behalf of the LLC. And in fact, it was argued at the hearing that in order for this document this presumption, if you will, that something that is mailed, stamped, and addressed is presumed received. In order for that to actually be correct, there would have to be actual proper addressing. It would have to be properly addressed.
Counsel, so to me, when I read the trial court's order, it's two grounds for and they have in their legal conclusion. And one you just addressed, and it's the presumption ground. And I saw a presumption argued in the motion for summary judgment. I saw a presumption argued by the movements counsel at the hearing. I did not see a response at the hearing from your side. Was that presumption, that legal presumption that they're argued, not the actual fact of receipt, but that there's a legal presumption in place that, Judge, you can hang your hat on and give a summary judgment as a matter of law? Was that legal presumption ever argued against by your side before the motion for rehearing?
I believe it was, Your Honor, for two reasons, or at least in two ways. One, or at least it was argued, and then it doesn't matter whether it was argued for two reasons. Let me just say it that way. The first, I believe it was argued at record page 226, where the argument was that we don't know who Zeus is. Zeus is not connected with the defendant, and the mail receipt document that attached to the affidavits is simply not documents that have ever been authenticated.
But that's an agency argument. So what I'm asking is a legal presumption argument. It seems to me that they're making an independent argument that a legal presumption arises because it was mailed, and they're going to say properly mailed, and therefore the court can presume receipt, and therefore, let me just say that. And the trial court also seems to say that the court says in its order, in Florida, mailed notice is sufficient to meet notice requirements. Then they cite the three cases that the appellee relies on, and then the court concludes by mailing the written demand to the address provided to the state of Florida and the tax collector, the trust complied with its notice obligations. To me, that's a legal argument, right? That needed to be rebutted at the hearing. Was that done?
I mean, it's somewhat of a legal argument, but it's also an evidentiary argument. So it requires an inference. Presumption is an inference. And so in order to rely on that, they're trying to fill in the absence of evidence using this inference. So the sufficiency of the evidence to support the summary judgment can be raised at any point, even on appeal. So even if it wasn't directly attacked, this presumption, it's still sufficient to raise it on appeal, especially when it was argued on a motion for rehearing. While the Supreme Court did change the summary judgment rule in 1.5, and it did not change 1.530, which specifically references the fact that the court can reopen the evidence on rehearing on either a bench trial or a summary judgment. So it didn't affect the case law that permits a party to file a motion for rehearing and raise additional argument or evidence, which is precisely what the LLC did here. And it's also what the trial court specifically said on the record that it was allowing it to do in quote unquote granting rehearing for the purposes of making a record. So even if it wasn't directly argued, Your Honor, in that presumption issue at the hearing on the summary judgment, it certainly was argued, I believe, at the rehearing phase.
So I want to get back to what Judge Ganem was asking. So if we take the movements, if we just look at the movements burden to show receipt, because that's the gap, right? That's what you're saying.
Sure.
It hasn't shifted ever to the respondent, to Lanigan, your client, because they did not satisfy their initial burden. What was missing from that initial burden? I mean, they've got, like I said before, they've got the good address, or I don't know if anyone tells the trial judge or not, that's not the good address. But if we've got an Abu Dhabi address, we have a signature. What was missing? What did they need to show?
Well, I don't think that they actually proved that they had a good address, number one. They argued that this was the only address, but the Secretary of State's website provides for actually other addresses, including the address that's in the LLC's name. But also they would have had to need to show that this supposed, first off, I'm not sure this receipt was admissible, but putting the admissibility.
But no one told the trial judge that at the initial hearing, right?
Fair. Nobody told that to the trial judge at the initial hearing, but the document itself doesn't connect the dots. It's very similar to that Chieli case versus City of Palms, I believe, where it actually, it just says Abu Dhabi. The sender's mailing address was Captiva, and the recipient's receiving address was Abu Dhabi. It doesn't actually contain an address. We have no idea where in Abu Dhabi this was supposedly mailed to on a Sunday, signed by somebody named X Zeus. And it was certainly argued at the hearing that X Zeus has no affiliate at the original hearing, not just at this rehearing, but at the original hearing. We certainly argued that X Zeus was unknown, that he, certainly didn't, there was no evidence that he had apparent authority. So in direct response to your question, Judge Brownlee and Judge Ganem, is if they wanted evidence, they needed to present evidence of apparent authority that X Zeus could sign for. The fact that there was a successful mailing and receipt 2 years prior does not fill that gap for them. Number one, it's another inference, which has to be drawn in favor of the movement. And number two, that actual mailing was signed by somebody different. It was signed by somebody named Ashraf, I think, or something like that. It wasn't X Zeus. So if there's any reasonable inference that can be drawn, it's that if you want to successfully say that there was receipt and payment, it needs to be signed by either Ashraf or the actual owner of the LLC, which is Lanigan. But even putting aside the issues related to what was presented at the hearing on the summary judgment, the rehearing in and of itself incorporated the original response, the evidence presented in response to the original summary judgment motion, as well as the deposition transcript of Colm Lanigan's assistant, all of which showed that there was no receipt of this document because it was not properly addressed. It didn't have Colm Lanigan's name on it as required by the Secretary of State's website, because it was being delivered, insofar as it was actually delivered to a building in Abu Dhabi. It was delivered to a 33-story building with 3,000 employees. So the mailing, a person in a mailroom is not going to, assuming that's who X Zeus is, the person in the mailroom is not going to have any clue who to give this to. In and of itself, even if there's putting aside the preservation argument or issues that your honor's raising, there certainly was not a preservation issue with respect to the argument that the summary judgment should have never been actually considered, because it was filed over a year past the dispositive motion deadline. In fact, the agreed case management plan and pre-trial order that was put in place and stipulated by the parties had in bold and underlined, the parties shall comply with the deadlines unless otherwise changed. And in order to change that, you had to prove good cause, and good cause required proof of an emergency or some form of unavailability. And none of that was actually raised or argued or presented in the motion. Instead, at the hearing, the trust tried to avoid the deadlines by saying, well, the Supreme Court changed the summary judgment rule and invited parties to renew. But that might be the case, but it didn't say it was a self-executing order that changed all stipulated case management plans and pre-trial orders.
Well, Mr. Sullivan, would the trial court have been within its discretion in response to this late filed summary judgment motion to simply say, well, based on the Supreme Court's suggestion that I should give everyone another try at this, I'll give you, Lanigan, this much time to respond. In other words, set a briefing schedule and just hear it sort of in the ordinary course. Would the trial judge have had the discretion to do that without going through this excusable neglect and these other standards that you argue?
Are you asking if they would have allowed continued the hearing and allowed for additional briefing, and et cetera?
Yeah, what I'm envisioning is the motion gets filed, you object to its timeliness, and the trial judge says, fine, I'll give you whatever time you need to respond. I'll set the hearing 20 days after that, and then I'll hear it in earnest. Would that have been within the trial judge's discretion without these findings of excusable neglect and those other things you've argued?
I mean, arguably, no. I mean, because the agreed case management plan was signed by all the parties and signed by the court, and the case law is very clear that agreed case management plans are binding on both the parties and the court. So in order for the court to have exercised its discretion in that scenario, then it arguably would have needed evidence of good cause, which had a very specific definition.
But couldn't good cause be the standard has changed and we have a right to renew our motion pursuant to the Supreme Court so that the court considers it under this new standard? Why wouldn't that be sufficient good cause for a trial judge?
If the order didn't actually define what good cause was, I could see your point, but here it was very specific in how it defined good cause. It said it defined it as matters arising from an emergency nature or unavailability. And I don't believe that the Supreme Court's change of the summary judgment standard qualifies here, especially not in this instance, where the trust waited 8 months after the change to actually file this on at the pretrial or the day after, or on the day of the pretrial conference. That wouldn't qualify for good cause or an emergency or any sort of unfair surprise. I mean, they even had notice, more than 8 months notice, because the Supreme Court sort of insinuated or said it was going to be changing the rule almost a year prior to that motion being filed. So at any point, sorry.
Did your client number one, am I correct? Your client did not move to strike the allegedly untimely, or it's untimely. Maybe that's undisputed. I don't know. We'll get there after, but there's no motion to strike, correct?
Correct. But I don't think that the rules, neither the rules nor the case law requires a formal motion to strike. As far as I know, I've not seen that. I mean, they certainly raised it at the hearing that this was untimely and the court shouldn't even be considering this, since there's going to be a trial in the next couple of days.
Is there some argument or some support in the record for the notion that because the case was continued so many times, then the deadline for filing dispositive motions may have been blurry or unclear because the trial date kept moving? Or is that language clearer in the agreed order?
That language, I believe, is clear because when I was trying to pull it up, and when the continuance orders were issued, or the sort of new pretrial orders, they specifically said something to the effect of anything that's not been specifically addressed here remains the same. So I don't think that it could be argued that it automatically changed the dispositive motion deadline from the original agreed order. I have a question. Is that
Yep,
already
you're in your rebuttal
calculated?
time.
Okay, then I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, Ted Tripp. I represent the trustees, Richard and Patricia Levinson. They were the plaintiffs in the trial court. Let me first deal with the issue of the consideration vel non of the amended motion or renewed motion for summary judgment. It's important to understand the procedural history of this case. The original case management plan was filed in August of 2020. It contemplated a trial in February of 2021. We had COVID. We couldn't get hearings. We couldn't get trials. And this case got continued, not once, not twice, but 3 times. So to suggest that somehow this court or the parties were bound by a deadline that was agreed to in August of 2020 simply makes no sense.
But did the
To your
agreed order
point-
say
I'm sorry.
something, excuse me, counsel, did the agreed order say something to the effect of all dispositive motions must be filed and heard 30 days before trial?
I believe it said a specific date. I believe the date that was
Oh.
set for the dispositive motions was in December of 20, February of 21. I can get you that date.
But they had a particular date.
They had a particular date for that deadline. And to your point, Judge Brownlee, instructively, that date had expired before the Supreme Court amended the summary judgment rule. So counsel would suggest that the Supreme Court, when they sought to allow trial courts to reconsider summary judgments that had previously been heard and denied under the old rule, which is exactly what happened here, somehow precluded from doing that in this case because of a case management plan that had been long overtaken by events.
So, Mr. Tripp, let me ask you this. I haven't done the math, but your opponent claims that it was 8 months after the Supreme Court made the rule change that this renewed motion was filed. So giving you every benefit of the doubt, is 8 months a reasonable amount of time to file essentially the same motion, but just citing the new standard?
The trial court said it was. The trial court in its order specifically found that the motion for summary judgment was timely filed, duly noticed, and afforded the opportunity to present a response by those opposing the summary judgment. So that's a finding by the trial court. And I would suggest to you, sir, that if nothing else, the decision of whether or not to hear a timely filed, properly noticed motion for summary judgment is a discretionary call with the trial court and comes to this court with a presumption of correctness and can only be overcome by showing an abuse of discretion. And tellingly, you haven't heard a single word about prejudice. There is no claim of prejudice in the trial court. There is no claim that you shouldn't hear this because we don't have enough time. There is no claim that you shouldn't hear this because we need additional evidence. The new rule specifically authorizes in these circumstances a request for the trial judge to give you additional time to file opposing materials. That request was never made. So that leaves us getting back to the first point with the fact that we have a summary judgment. The trial court, in its discretion, determined that it was timely filed, duly noticed, and properly before the court. No abuse of discretion has been shown in that decision by the trial court. So we now have a motion that is being considered under the new rule 1.510, and under 1.510C5, there is a burden imposed on the opposing party. They must file an opposition within 20 days. And as the 4th District opined in the Dombrowski case, there is no wiggle room in the word must. The rule says you must file 20 days before, and this appellant did not.
Mr. Tripp, does the absence of a response mean you automatically win?
The absence of a response, according to the plain text of the rule, says that the court may either grant additional time to present evidence or opposition, which was not requested here, or, and I'm quoting from the rule, may consider the matters to be deemed admitted. And if you look at paragraph 10 of the motion for summary judgment, one of the matters that the rule specifically authorized the judge to treat as being deemed admitted for the purpose of the motion was that this demand was properly sent to the address provided by the LLC and it was received by the LLC. The defendant in this, I'm sorry, sir.
I was just going to ask you, let's talk about the initial burden of the movement. The Celotex court said, of course, the movement still bears the initial burden of establishing that there's no dispute of fact,
That's
no
correct.
genuine dispute of fact. I want to talk about here the movements. Seems like the primary basis for the movement's motion below was that the Levinsons sent this to the only address there was. It was in the property appraiser website. It was at the state of Florida Division of Corporations. But the very exhibits attached to the movement's motion show an address in Abu Dhabi on the property appraiser's website, but a lot of different addresses on the state of Florida Division of Corporations website, which is the official repository of the LLC's annual report. And I see in there an address at the Captiva property, the registered agent name and address. I also see a mailing address for the LLC that says attention Colm Lanigan, and then provides an Abu Dhabi address that's similar, but not identical to the one on the property appraiser's website. So what I'm trying to understand is if the factual assertion that you want the trial court to deem undisputed is that there was just one address, can the trial court really do that if your own exhibits show that there's more than one address?
On the undisputed facts of this case, the answer is yes, and I'll tell you why. First of all, you have to understand this comes in the context of a violation of Florida law by the LLC. Florida provides for how you communicate with artificial entities like corporations and LLCs. You name a registered agent who is available within the state of Florida to receive notices on your behalf and is obligated to provide those notices to the entity. In this case, it is undisputed the LLC did not do that. It designated a registered agent in Abu Dhabi.
Well, when I look at the exhibit filed with the state of Florida, it says registered agent name and address, Colm Lanigan at the Captiva property. It shows a mailing address in Abu Dhabi. But there's no evidence, is there, in this case, that the Levinsons attempted to mail anything to the registered agent, Colm Lanigan, at the registered agent address on Captiva?
The answer is no such effort was made because no such effort is possible. The record in this case shows that the Captiva residences don't receive mail. They have no facility for delivering mail to that address. If you look at the letter that was attached to Mr. Lanigan's affidavit from Clay Crevasse, you will see that Mr. Crevasse confirms you can't send mail to either of these two houses because Captiva doesn't deliver mail to houses.
What would happen if someone addresses a letter to one of these houses and puts it in the mail?
It is unclear to me what would happen. That is not in the record, and I honestly don't know the answer to that question.
Well, let's go back to this premise that there was just one address available. But the LLC annual report, one filed with the state of Florida that the Levinsons authenticated through Mr. Lanigan, says the mailing address is attention Colm Lanigan, followed by the Abu Dhabi building address. Why isn't it important that the Levinsons didn't send it attention Colm Lanigan when that is what is in the official filing with the state of Florida for this LLC?
Two reasons. First of all, if Mr. Lanigan wished to have notices delivered to his LLC in a certain way, he could simply have so stated. On this record, Judge, what we have is Mr. Lanigan receives a notice in 2017 for minor maintenance. He gets it at the same address to which the 2018 bill was sent. Mr. Lanigan's response through Clay Crevasse, and this is in the record, is we received the notice at this address in Abu Dhabi, but Mr. Lanigan was traveling, his payment will be delayed, and so we'll send you a check. And that happens. So the evidence is that that address works for sending and receiving notices.
But does the fact that it was received in 2017 establish as a matter of law that it was received in 2019 just because it was mailed to the same place?
No, but the receipt does. The receipt is authenticated by Richard Levinson's affidavit, who says that he placed the notice with the invoice in an envelope addressed to this location, put it in I think it was UPS, but the mail effectively, and received back a receipt signed by someone at that address.
Counsel, do you need
Now-
to establish agency for the person that signed? I know below you said that if, I think you told the trial court, if you're requiring me to prove up who X Zeus is, then please don't grant my motion. So how do you establish agency on behalf of the person that signed to show receipt?
I would suggest that we have shown apparent authority that the address to which we were told to send notices has someone who receives mail notices, signs for them. What further can we do to raise the presumption of the delivery of a notice, putting aside the fact that it worked the previous year?
Can that presumption be rebutted? Can the presumption be rebutted?
It certainly could have been provided had the defendant filed a response in opposition to the motion for summary judgment, which they did not do, which they were required to do, and which therefore authorized the court to deem admitted the transmittal and receipt.
Let's
But
go down that rabbit hole. What could they have said that would have rebutted the presumption as a matter of law?
They could have said that the receipt was signed by someone who was not authorized to sign for mail addressed to the LLC. They did not say that. They could have said, we received the envelope at this address, but I was traveling. In fact, that's what happened on this record, if you'll recall. Mr. Lanigan left Abu Dhabi in 2018, September of 2018, and didn't tell anyone. He moved to Bhutan.
Well, Mr. Tripp, I think we could go outside of the movements papers here and find an explanation for what he did to make sure he got his mail. But I don't think we want to go there. I think we want to focus on the movements papers. And there's a case out of the 4th DCA. It's WT Holding v. Florida Agency for Healthcare Administration. And there it says, in a case where the presumption of receipt arises upon mailing to a proper address and those requirements are met, it says that presumption can be rebutted by a denial of receipt, and that denial at least creates an issue of fact for the trier of fact. Now, here we understand Mr. Lanigan or the Lanigan LLC didn't file a response below, but the face of the Levinson's motion says that Colm Lanigan says he didn't get it because it wasn't addressed attention Colm Lanigan, and it cites to his deposition testimony that establishes that. So can the trial court, for purposes of this presumption of mailing, can the trial court not rely on the face of the movement's own motion to find that fact of non-receipt, or at least that claim of non-receipt that rebuts the presumption?
And Judge, thank you for that question, because it is the key to this case. This notice was not received by Colm Lanigan. Colm Lanigan was not entitled to receive any notices. Colm Lanigan decided to put this entity in the name of an LLC. It is the LLC that gets the notice. And Mr. Lanigan has tried to conflate the fact that I never got it. I was in Bhutan. I was in 25 countries in 6 months, I believe he said. But Colm Lanigan is not the property owner. We're required to send notice to the LLC itself.
Counsel, who acts for the LLC?
I'm sorry?
Who represents the LLC? Who
Yeah.
acts for the LLC? Who could you have sent this to if not Colm Lanigan?
I have no idea who acts for the LLC unless the LLC tells me, and that's the problem, Your Honor.
But didn't the LLC tell you that it has to say attention Colm Lanigan? And that's on the face of the renewed motion for summary judgment. And in the depo transcript, that your client filed in the record. And so even if we take out his personal name, right? And we just say, where were we going to send this to the LLC? And the LLC says, attention Colm Lanigan, doesn't that then at least show the trial judge at the outset that there is a discrepancy between where you sent it and what was required in order to send it validly to an LLC?
No, because, and the because part is, we sent it to that same address in 2017 and it got paid. So yes, the LLC could have told us, and I do want to come back to something you said, Judge. The LLC never told us where to send anything.
But does the easement require the owner or either owner to tell the other owner anything at all?
It does require the other owner to send a notice. But the point I'm making is the failure to receive in this case rests at least in part on the LLC's failure to name a registered agent or tell us where the heck to send the notice. We had to go to the property appraiser and to the Division of Corporations. So this is not a communication to us. And the trial court in this case could have concluded that this was the functional equivalent. No, I won't say that. It sounds too. That the failure of delivery in this case was due to the failure of the LLC to take appropriate steps so that notices could be sent and received appropriately. So I think I would conclude by saying, we have 2 minutes left, we can't lose sight of the fact that this is an easement agreement. Neither of these folks negotiated this agreement. It was of record when they bought. They are stuck with this agreement. This agreement identifies as minor maintenance expenditures of less than $500. So this agreement says that if you don't pay 1/2 of your minor maintenance, the easement terminates automatically in accordance with its terms. Why would they do that? They would do that precisely because of the kind of dispute that brings us here. The appellant would tell you that in order for Mr. Levinson to succeed on his claim, he should travel to Abu Dhabi, take the deposition of the person who signed for the mail in order to establish his right to recover $150. That is not what the drafters of this easement contemplated. They contemplated that minor maintenance would occur, bills would be provided. Wherever you want to send the bills, let me know. But if you don't pay them in 30 days, the easement terminates in accordance with its terms. Under the new summary judge standard, that motion, the renewed motion, was within the trial court's discretion to hear. It was timely filed. It was properly noted.
Counsel, what do you say to Judge Gammon's question regarding there being a dispute in the evidence presented? Have you met your burden when there's a dispute in the evidence attached to your motion on the proper address?
I'm sorry. Would you ask me that question again?
Sure. Judge Gammon brought up the point that attached to your motion for summary judgment
Right.
was evidence which showed multiple addresses, not one proper address, but multiple possible addresses. How can you succeed on your motion for summary judgment when there's multiple addresses which may be proper? Does that not itself show a dispute?
And the answer is it may be if you file a timely opposition as required by the rule. But if you do not, the rule itself says that the court may take as undisputed the facts in the motion. And in paragraph 10, those facts were alleged in our motion and they were not disputed. The question I think you want to ask me is, Can you solve that problem if you belatedly file a motion for rehearing and assert additional evidence at that time, which is in fact what happened here? The trial judge did allow for that additional submittal, and it did not alter his determination. We think the trial court should be affirmed. If there are no other questions.
Honors, I believe there's 4 points I'd like to try to make. I'm going to work backwards, start from my opposing counsel's beginning with the timeliness of his motion. I believe he emphasized that there was a lot of continuances because of COVID, but I don't believe that COVID prevented from filing his motion for summary judgment much sooner, or having it even heard much sooner. And to Judge Brownlee's point, let me get my iPad to say this correctly. The agreed case management plan had a specific deadline. The pretrial order on record page 715 is where it included the fact that the motions must be filed 45 days prior to the pretrial conference and heard 30 days prior to the commencement of trial. And it goes on to say all motions not heard as set forth above will be deemed abandoned. So
was the argument to the trial judge on just the case management plan, the uniform trial order, or both?
I believe it was both, but I'd have to go back and review the record to double check that. I think that they were argued together, that there was a deadline and the deadline was not complied with, and there was some confusions. I believe, and I'm not putting words in my opposing counsel's mouth, that he didn't believe that there was a deadline, and that was proven.
Well, if you
incorrect.
just look at the case management plan, and my understanding based on what y'all are telling me is that the case management plan has a specific date delineated in it. It's not that broad language from the trial order 45 days before pretrial. So if it has a specific deadline and that deadline has long since gone, and then there's a renewed motion, I mean,
Still in time.
well, wouldn't it be couldn't it be timely then under the uniform order and then untimely under the case management plan? I mean, which one prevails? Isn't it ultimately the trial court's discretion to control its own docket?
Well, it is in some respects, except when there's an agreed case management plan that then controls the course of the conduct for.
So then that is
Superseding.
it. Yeah, I don't know if I want to say superseded, but I guess that is more important then, right? To put it inartfully, but so that is going to be the most pertinent date, not a date of 45 days before trial.
I believe, but he wouldn't be compliant with either one of those.
Okay.
The next point I would like to make is that there is no requirement to file a response to summary judgment. It certainly doesn't relieve the burden of the movement to prove that he or she is entitled to summary judgment. The must language is kind of referring more to the context of if you're going to file a motion or a response, you must do it within 20 days of the hearing. So I think there's too much emphasis being placed on the must language. I believe there was even a case out of the 4th DCA, Bararto, I think, that said you still got to go through the analysis. You don't just automatically win. There has to be entitlement to summary judgment.
And so, counsel, with regard to filling in those details, just before you pivot, my understanding is your argument is they did not satisfy that initial burden because they haven't filled in the details of what even is this printout that we have that supposedly demonstrates receipt. But what your opposing counsel has stated is, indeed, there was an affidavit attached to the motion for summary judgment that does fill in those details, that states I mailed it on X date, I've got the printout here. Why is that insufficient to fill in those details if that is your position?
For several reasons, I think it's a bit of an oversell on the affidavit. I don't think the affidavit sort of authenticated that document. It said the document attached to the complaint in Exhibit 4 shows evidence of mailing. And I don't think there was enough connecting of the dots, but even if there was, it's certainly the document itself doesn't connect the dots because it's just there's several problems with it. And I know we've already addressed a lot of them, so I won't go too far into that, but the receipt doesn't even say where in Abu Dhabi it was delivered. And the document that the actual demand doesn't include the attention call Flanagan, which there was a statement that if they wanted it to be sent a certain way, they could have said it. Well, they did say it on the the Secretary of State's website. It said it had to be attention Colin Flanagan, and it actually had a registered agent on there that was specifically the address in Captiva.
But was that your client's position, or was your client's position before the trial court that it should have been emailed to counsel or to Mr. Lanigan directly?
I'm pretty sure that both at the hearing, the summary judgment hearing, and on rehearing, that it was argued that it should be sent to that it wasn't dressed properly because it didn't include Colin Lanigan. If I'm mistaken on that, I apologize. I know it was definitely argued at the rehearing, but I thought it was hinted at also at the hearing on the summary judgment. I see my
Counsel,
time's up.
you are. Thank you, counsel.
Thank you, Your Honor.
Thank you.
When I addressed the one issue that just now is had to the content previously.
No, counsel. I'm sorry. I want to thank you both for your time today. It was well argued. We'll be in recess.